Well, hello everyone. Welcome to another late night tea hour with your friend Uncivil Law. Here comes the tea, do 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 do. Here comes the tea, do 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 do. It's all right. Yes, we have an update in the ongoing beauty YouTube legal drama that is Toddy versus KJ without a crystal ball. We have an updated filing from Toddy's side. In fact, we have three of them technically. We have a motion, we have a declaration, and we have a joint discovery agreement. It's a little early for that, actually, which suggests that they think that they're going to discovery, which suggests that they don't think the motion to dismiss is going to be granted. It's a little early for a joint discovery agreement. Because if you really thought the motion was going to be to dismiss would be granted, there'd be no discovery. So why do you have a joint discovery agreement at this point in the case? It suggests that you think you're going to discovery. It suggests that you think that your motion is not going to be granted to dismiss. So, is that a tell? It's a little early. I just take note of that. It's a little early for there to be a joint agreement. So we got three documents. We got a motion, we got a declaration, we got a joint discovery agreement. That's fun. And we're going to read them. And we're going to react to them and share. And we will give our standard disclaimers in the hope that people will continue to understand the standard disclaimers. So this is coming from Toddy's side, which means that we will interpret it against Toddy, because Toddy, writing it for her side, is trying to make it look as good for her as possible. So we will naturally look for holes and interpret it against her. Right? She's purposely trying to make herself look as good as possible, so we're going to look for holes and interpret everything we can for KJ's side, except, of course, the joint agreement, because it's a joint agreement. So we'll look at that neutrally. This is our standard interpretation policy, so that's what we're going to do. And thank you very much for the super chat. That is very, very kind of you, $5. I don't normally donate to streams for economic reasons, but for starting the stream within 19 minutes of it being your birthday, you get a cookie. Well, I'm very happy. Happy birthday. Thank you very much for your joint donation or your donation. That's very, very kind of you, especially in these difficult economic times. I really appreciate it. All right, let's go ahead and get started. We got the precipice, which is a very fancy word that I don't normally see. It's just a supplemental motion, but we're going to give it a very fancy word. It's a little pretentious, but that's all right, I guess. And we're going to, it wouldn't be my word choice, basically. It's a little much for me. But we're going to read this, and we're going to see what it has to say. It's only 4 pages long. This is the motion, and then we got the declaration from Saltz, and then we got a joint status agreement, which I think is like 6 pages. So let's get started with this. It's not very long, all things considered. Pursuant to the local rules, 7M. All right, so we can actually have some legal intelligent commentary. This is part of the thing that makes the practice of law really, really complicated. Even more complicated than it really needs to be quite honest. But here's something you need to know. This is very true in federal court. I can't speak to how true it is in state court because my practice is federal. But it's very true in federal court. All right, so you're in federal court, and you'd like to know, what are the rules? That's a good question to ask. Like, what are the procedural rules? What is the process rules? Well, there are the federal rules of civil procedure. We're assuming we're in a civil case because there's the federal rules of criminal procedure as well, but we don't need to get into that. So we'll just assume we're in a civil case and we're in federal court. 2 assumptions: civil court, federal court. All right, so if you want that, we start with the federal rules of civil procedure. That's a good place to start. However, that's not where you end, because the local courts almost always have local rules, and the local rules supersede the federal rules. But wait, there's more. Each individual judge almost always has rules on top of that supersede the local rules. So that means that usually you're dealing with 3 sets of rules. You have the federal rules, which are beaten out by the local rules, which are beaten out by the judge's rules. And you have to keep all these things in mind and keep them straight, which is a bit of a pain in the butt. But yeah, so this is pursuant to a local rule, which beats the federal rules. And this is part of why being a lawyer is complicated, because you have to remember all these things and remember what takes precedence over what, and remember to look. which is actually a lot harder than you would think because a lot of lawyers tend to screw it up. But anyway, pursuant to the local rule, not to be confused with the federal rules, the plaintiff submits this document to add an additional document in support of their previous filing, the opposition for defendant's motion to dismiss. So we want to oppose the motion to dismiss, which we have lots of valid grounds to do. Not for at least the reasons that we didn't move to dismiss on every count. So there's that, which I suppose means that we're going to discovery because, assuming that the personal jurisdiction fails. So the personal jurisdiction is the only thing that would prevent us from going to discovery at this point. Because if there's no personal jurisdiction, we can't hear the case, and we would transfer it. All right. Specifically, the plaintiffs seek to add into the record a declaration showing additional factual support for the plaintiff's argument that defendants derive income from Washington through the publication of defamatory content. So one of the things that we want to try to show is that we can bring the defendant before this court because the defendant receives income from this court, and therefore the defendant has an interest in what happens before this jurisdiction. Such information was not included with the previous filing because it only came to undersigned's counsel's attention after the filing of plaintiff's opposition. How did it come to your attention after the filing of the opposition? On December the 29th, 2020, defendant broadcasted a live stream in which they discussed the lawsuit. Yeah. I can't obviously speak to what Katie's lawyer advised Katie with respect to this issue. And maybe her lawyer told her it would be okay to talk about the lawsuit, and I'm not one to quibble with another lawyer and their advice unless I can really get inside their head, which I'm not going to do right now. I would simply say that for myself, it seems like a bad plan. The standard advice from most attorneys would be for their client to keep their mouth shut. This was advice that was excellently taken to heart by Carl Benjamin, otherwise known as Sargon of Akkad, in his lawsuit against Akilah Hughes, otherwise known as Akilah Obviously, whereas Akilah Obviously not so much on taking it to heart, and in no small part to Akilah Hughes, Akilah Obviously opening her mouth, she lost the case. In no small part to that. The judge definitely took notice and made a special mention of it. So the standard legal advice in a lawsuit would be, please close your mouth about the issues in the lawsuit because your opening your mouth only hurts. Apparently, either Katie didn't get that advice, she got contrary advice, or decided to ignore that advice. But in either case, it seems like this decision may have somewhat undermined her legal interests. Okay. Yeah. The members only mode was for the live chat, in which a person using account believed to belong to Laurie Ann Barnhart participated and sent paid super chats to the defendant. The video definitely shows this person known as Laurie Ann Barnhart, whose online presence shows that she lives in Washington, was a paid member of defendant's channel as of the date of the video. The revelation prompted an in-depth investigation into the approximately 1,600 videos that are currently visible on defendant's channel to determine if Miss Barnhart's account was a member before the lawsuit was filed. The reason this evidence was not discovered earlier was that undersigned's counsel did not have any knowledge that Laurie Ann existed prior to the filing of this lawsuit, or prior to the live stream video, or her connection to Washington and the videos that established her membership had innocuous titles unrelated to the plaintiffs. Defendants have so many YouTube videos, many of which are more than an hour long, that would take years to view them all in their entirety. The knowledge that Laurie Ann is a member of the defendant's YouTube channel only came to undersigned counsel's attention through defendant's broadcasting of a video about this lawsuit on December the 29th, 2020, with the members-only chat turned on. Once again, I can't necessarily speak to what Katie's lawyer advised Katie, but you should go ahead and continue to do live streams about this lawsuit does not strike me as necessarily the best legal advice, but maybe Katie's lawyer has a better plan. Undersigned's counsel certified that they met and conferred with defendant's counsel on December 30th, 2020, and informed him of the intent to submit this document with additional documents in support of the motion to dismiss. always a good thing. Make sure that the other side isn't blindsided, which is incidentally why I was not a big fan of the throwing the other lawyer under the bus part of the other motion, because it would inhibit these kinds of discussions, which are very helpful to avoiding things being dragged out for both sides. Undersigned counsel also informed the defendant that they would stipulate to allow defendants additional time to submit the reply to avoid any prejudice to the additional record. So they said, yeah, you can have additional time to deal with our motion in your response to our response. Great. All right, so that's fine. So next up, let's read the declaration. Fun. Lori Smith, happy birthday. It's not quite my birthday, but it will be soon. And thank you for your valuable time. You're very welcome. I appreciate that, Lori. Thank you very much. I'm getting old, which is marginally better than the alternative. I thought you're live tomorrow. I am live tomorrow. I will be live tomorrow. We're doing a weekly hangout. I can be live other times too. Just because I'm live tomorrow doesn't mean I can't also be live now. We're also live tomorrow. Tune in, 7 o'clock Central Time, for what will be the first episode of our weekly hangout. We do hangouts from time to time, but we've done them on an intermittent, in unscheduled basis. So now we're going to try to pick a time of the week, and we've picked Tuesday for a first attempt. So tomorrow, Tuesday, and hopefully every Tuesday if it goes well, 7 p.m. Central Time, we'll do Q&A, hang out with the chat, and all that kind of stuff. It should be fun. So let's press on. So we have the declaration of Saltz. So the attorney wants to file a declaration. All right, so let's listen to what Saltz has to offer us. I, Michael J. Saltz, hereby state the following. I am an attorney admitted pro hoc vice to appear before the U.S. District Court for the Western District of Washington, and I'm a partner of Jacobson, Russell, Saltz, Nasim, and De La Torre. I submit this declaration in support of the opposition defendant's motion. I did not previously submit this declaration, as new facts have come to light which could not reasonably have discovered prior to the filing of the opposition. So he's providing the legal basis for why he's doing this. This is new information that's come to light. That's why I'm doing it now and not before. All right, great. That's, kind of important. Specifically, since filing of the plaintiff's opposition, defendants have disclosed additional evidence confirming that, contrary to the statements made in defendant Paulson's declaration filed in motion of dismiss, defendants have knowledge they derive income from residents of the state of Washington. Such evidence confirms that said income is derived through super chats and paid channel memberships in which they've entered into contracts to provide in exchange for a fee. I don't know if that's technically the right way to think of it. I wouldn't think of either memberships or super chats as really a contract. Yeah, I'm not sure that's technically speaking a contract, but maybe that's it's kind of a point without a difference. I just wouldn't use the word contract. And it's not necessary, but that's a very minor quibble. To provide for a fee exclusive content and services to people defendants have reason to know are Washington residents. Maybe it is a contract. I just haven't really thought about that hard. Is it a contract or not? I don't know. We could have a legal debate on it, but it doesn't matter. Because defendants failed to disclose that derived income from performance of their contractual obligation to provide exclusive content to known Washington residents through paid memberships. I don't like the way that's phrased because it suggests that we're providing exclusive contents to specifically known Washington residents, as opposed to them merely being incidentally known. So I don't particularly like that phrasing, but maybe that's a tactical choice to make it a little bit more, it's not wrong. It just leads to a slightly incorrect implication, but maybe that was by design. The evidence of defendants deriving income from a known Washington resident did not prevent itself until a week after filing of the opposition. What is more, said evidence was made more difficult to find and otherwise comprehend due to the fact there's been a concerted effort to obfuscate and or destroy the evidence. That I do like. If you're gonna argue some spoliation, now's a good time to mention that. Excuse me. By way of example and not limitation, I watched and simultaneously recorded a video, All This Needs to Stop, that was streamed live on December the 29th on defendant's Katie's Joy's live YouTube channel. Hey, Katie, it turns out that you have at least one new member, the lawyer for the opposition. During the December 29th, 2020 video, defendants attempted to downplay their otherwise previously public connection to a member of their YouTube channel, Laura Ann Barnhart, who is known to me to be a Washington resident. The member named Laura Ann has identified by her YouTube assigned author ID of whatever as her personal identifier on YouTube. Regardless of what published name she uses on YouTube, the author ID remains the same. She's also the same person known as Laura Ann with the account numbers of @Bloodtail, I don't want to know where that comes from, @Lab05059, and @Lab050505 on Twitter. As the same person assigned as profile ID whatever on Facebook for an account that uses the name of Laura Ann Barnhart, and more recently, Laura Ann Peroni. The same Laura Ann is identified to be a person that is referenced in the declaration of Kim Follner, supplemented by the plaintiffs in conjunction with the opposition. During the All This Needs to Stop video, a person using said Laura Ann video YouTube account sent, yeah, I do like that, because technically speaking, you don't know it's Laura Ann. In the strictest possible sense, you don't know it's Laura Ann. You just know it's someone using her account. It's reasonable to think it's Laura Ann, but strictly speaking, you don't know. So I do like that. It's very carefully phrased. Good job. I wouldn't have noticed it if it had been the other way around. This is just a much more cautious way. So this is attention to detail that I probably wouldn't have used, and I wouldn't even thought about, but I do notice someone else using. Because strictly speaking, you don't know it's her. Strictly speaking, it could be someone else, right? So somebody who happened to be using that account, whoever that might be, sent defendant multiple super chats evincing direct commerce between a Washington resident and defendant. As stated in the declaration of James Westbrook, a super chat is a payment of funds from a viewer to a YouTube channel during a live stream video that is paid through a live stream chat. I wonder what super chats are. If only someone could show me through super chats right now. Below is a true and correct copy of the screenshot of the super chat sent in by Laura Ann's YouTube account. Defendant and I obtained while watching the video at approximately 13 minutes this in. Oh man, a lawyer had to actually watch this in real time. That's funny. So now we have a copy of her chat. Let's see if we can zoom in a little bit. The graphics are what they are in the original, so not super great, but there is presumably without a crystal ball herself, and we got her super chat. She's reading some sort of messaging thing, and we've got some messages, and we got the super chat from Lorianne, $14.99. Toddy's lawyer is a creep that needs a restraining order. He's been passive aggressively me. That's not English. He's been passive aggressively me. That's not English. Try again. Since this has been my most vocal in standing up for you, this is all my fault. Well, it's a little bit your fault. Yeah. 420 from Rick. Is this a super chat? It's the most super chat of all, Rick. You're the best. Thank you. It's a little bit your fault, Lorianne. But more properly, it's Toddy's fault for, the defamation. It's more Toddy's fault for the defamation. Or at least the alleged defamation. Or the alleged tortious interference. Or the alleged whatever. Because I still think there's some good defenses, even though she hasn't made them so far. Additionally, below is a true and correct copy of the screenshot of another super chat. Chat sent in from Laura Ann's YouTube account to defendant. The defendants rebroadcast it in their video portion of the live stream that I obtained while watching said video at approximately 17 minutes therein. We have another super chat. There is presumably without a crystal ball herself, who looks like she's a little battle worn. These are people that are involved, so I can't completely look past the fact that it is a person. She looks a little battle worn. Maybe not making the video would have been helpful though, just as an FYI. From Lorianne, $4.99. I cannot believe you're even entertaining this guy, Katie. He's sick, violent, and harasser. So is PJ. Okay. The development is significant because, as stated above, the person I know as Lori Ann is also known to, when you're looking as battle worn and as worn out as you are, I can only think to myself at this point that you really need to take better care of yourself. And have you considered the wonderful skincare products from Halo Beauty? Halo Beauty, there to help you get rid of your tired, worn out appearance and be the radiant beauty you always had within. Halo Beauty, there for you in your trying times. I'm so sorry. This development is significant because, as stated above, this person I know as Lori Ann is also known to be a resident of the state of Washington, a fact that has been presented in plaintiff's opposition, and which Lori Ann has effectively admitted herself in unsolicited messages sent from her Twitter account to me shortly after filing said opposition paper. To be certain, said message expressly stated that plaintiff, and especially myself, have doxed her. I think that also external beauty is slightly overrated. You can only do so much with external beauty, and what you really need to do is you need to really repair yourself from within. Really heal the inside of yourself, and that will allow that natural beauty to really shine through. So rather than the Halo Beauty products, may I suggest Halo vitamins and supplements that will help you in helping your inner beauty really shine through. Halo vitamins to help the real you shine from within. $9.99 from Amy Sorensen. That was amazing. You're welcome. By stating that she had been doxxed, Lori Ann appears to have admitted that the personal identifying information is true, as one cannot be doxxed with information that's not their own personal identifying information. I never really thought about it before, whether or not that's strictly speaking correct. Maybe that's a bit philosophical. Can you be doxxed with information that's not accurate? I don't know if you consider that to be doxing or not. That might be a bit philosophical. Yeah. Send messages were sent to me on December the 24th, 2020. Okay, a true and correct copy of the screenshot I've obtained from my Twitter direct messages below. A direct message from Lori Ann. I suggest you stop doxing me and accusing me of things I haven't done. All those trolls that surround you are the harassers. You call yourself a professional, let you allow your troll army to dox me. Unless you have proof I've done anything even close to illegal, you best stop it. You've already doxed me and you don't even know who the hell Toddy is, nor have I supported Katie for months because I was harassed and stalked. I think that's part of his argument, is specifically that you haven't been supporting her, at least in part, and that might be part of the damages, if I understand the theory of the case properly. I did not respond to these messages, nor have I sent her any direct messages, let alone any messages of harassing or threatening message nature. I wouldn't expect you to. Said super chat payments from Lori Ann's account to defendants through defendants' YouTube channel established that defendants do earn an income derived from the state of Washington. A true and correct copy of said video without the live chat or comments I've downloaded from the YouTube channel is placed in the Dropbox for the court's convenience and become located at this address. So if you want to get the Dropbox video, it is available for you. Said super chat screenshots show at the bottom of each respectively that said live stream limits the participants of ongoing live chat to videos for members only. Membership involves a monthly fee for the individual. And so since she's a participant, therefore she's a paying person, and so forth and so on. Yeah, fair enough. Upon seeing that said live stream chat was reserved exclusively for defendants' paid members, I investigated the membership information published on defendants' Katie Joy Live YouTube channel. I learned the defendants charge a recurring monthly membership fee for members on an increasing sliding scale to the level of perks. That is, contractual services and content to be provided for defendants, for which a particular paying member wishes to contract with defendant. Specifically, defendants sell recurring monthly memberships to the Katie Joy Live YouTube channel as follows. Incidentally, if you're out there, Toddy's lawyer, I would like to remind you, Toddy's lawyer, that for a mere 99 cents a month, you too can become a paid member of this channel. If you just hit the join button, that should be somewhere on your screen near the subscribe button, you too can become a paid member of this legal channel. And you also will gain wonderful benefits by becoming a member of this channel. For example, you will get your name in green. You will get access to members-only content, such as batch records and other off-branded content. And most importantly, I will like you more. So if you're Toddy's lawyer, if you're KJ's lawyer, if you're Toddy, if you're Katie, or if you're anyone, please become a member today. If Toddy's lawyer does not become a paid member of this channel, I'm just saying, man, feeling a little bit of disrespect. Just a tiny little bit. I'd become a paid member of your YouTube channel if you had one. I learned defendants charge recurring monthly membership fees for these people. Specifically, defendants sell recurring monthly memberships to the Katie Joy Live YouTube channel as follows. A stan, pays. Do they have footnotes for this? Apparently, they do have stan. They do have footnotes. A stan is a social media vernacular for a person who is both a stalker and a fan of a particular personality. Okay. So for $1.99, you can be a stalker fan. Okay. A vlogging queen pays defendants $4.99 recurring monthly fee. A KJ Ultimate Stan pays $9.99 fee, and an Ultimate member, which I'd like to point out that, strictly speaking, you can't have an ultimate followed by another ultimate. The word ultimate means last. You can't have an ultimate level followed by another ultimate level. The word ultimate means final. There's nothing after ultimate. That's what ultimate means. Perhaps you should rename it KJ Penultimate Fan? Just a suggestion, if we're interested in nomenclature. Both are true and correct copies of screenshots of defendants' Katie Joy Live's YouTube channel membership I had obtained from the channel, and wherein the services and content for defendants are being offered to be contractually bound to provide said memberships as set forth. Can I please define stalker? Well, apparently in this context, a stalker is obtained through a $1.99 recurring membership fee. Apparently that's the definition of stalker in this contractual relationship. So, Yeah. Yeah, so we got to join the channel for a stan for $1.99, vlogging queen for $4.99, ultimate stan, and ultimate member. So a stalker fan is less than a member? All right, I guess. I don't know. Should I become a member of Katie's channel? Apparently for $24.99 a month. Apparently for $24.99 a month, I can get shout outs in videos on a contractual guarantee. Should Uncivil Law become an ultimate member of KJ so that Uncivil Law can get the contractually guaranteed shout out and videos that he so richly and rightfully contractually deserves? It's a thought. It's a thought. I also then investigated the membership information published on Defendants Without a Crystal Ball YouTube channel. I learned defendants charge recurring membership fees for members on an increasing scale related to the level of perks, contractual services, and content to be provided for by defendant, of which a particular paying member wishes to contract with the defendant. Specifically, defendants sell recurring membership fees to the Without a Crystal Ball channel as follows. A super fan pays $3.99, a standing pays defendant $9.99, and Next Level pays defendant $24.99. Below are true and correct copies of Without a Crystal Ball's YouTube channel membership information I obtained, and wherein services are offered and contractually bound to provide said forth. I don't know if I really thought about it as a contract before. I'm not strictly speaking it's a contract, but it's kind of contract-like. It has sort of the... I don't know if it's really speaking a contract, but, you know, we could quibble about that. She looks better in that photograph, I guess. Maybe that was a period when she was using the Halo beauty products or something, because she looks a little bit more alive in that one. Ooh, you get some custom emotes too. Oh, I didn't notice the custom emotes. Do you? No. Oh yeah, you get custom emotes. Can we zoom in on this? Oh yeah, no, we got to check you get some custom emotes. Oh, look at this. You get some loyalty badges. So you get a clear crystal ball, a red crystal ball, a green crystal ball, pink crystal ball, purple, and then multicolored for different levels of membership. And then you get Katie coffee. Women support women, apparently less so in this case. What looks suspiciously like a tea bag with the word tea on it. Some sort of coffee cake. I can't even, not defame people, not something available, not joyfully maybe, not joyfully available. Yay pants. She's a fan of pants. Okay. What looks like a kitten in a coffee jar. Love is love. A bear with something written on it. Joyfully unavailable. What looks like a judge's wig. And Tool Canoe. Canoe? Cannon. Something. All right. So if you're interested in those emotes, those are available for you for the low price of $3.99 a month on the Without a Crystal Ball channel if you're interested in that kind of thing. As explained by YouTube, there are 6 different loyalty badges that can be assigned to a paid member of the YouTube channel, and each one highlights how long the viewer has been a member of the channel. The color of the badge indicates how long each member has cumulatively paid for membership. $5 from Triple Herbal. It always smells better when I F into my cupped hand and immediately inhale through my nasal cavities. Okay. Noted. I'm glad that that's working for your olfactory senses. I'm glad you found a smell that pleases you and one that you're able to produce on command. How convenient. Excellent. For example, if an active member joined a channel a year ago but only paid for a total of 9 months out of 12 months, the badge will show they've been a member for 9 months. The durations associated with the 6 badges of membership are followed. New, 1 month, 2 months, 6 months, 1 year, and 2 years. Information regarding YouTube's channel membership badges can be found at wherever. Hello, Ashley's pretty little life. How are you? After I determined through evidence cited above that said Lori Ann YouTube account was a paid member of defendant's YouTube channel, I then attempted to determine if said Lori Ann YouTube account had been a paid member of defendant's YouTube channel prior to filing this lawsuit on October the 30th of 2020. This required my staff and I to review and research 65 videos on the defendant's channel and approximately 1,540 channel videos on Without a Crystal Ball YouTube, with said video remaining in length from 1 hour to 3 hours. Did you actually review all those videos, you and your staff? That would be an insane amount of time. I'd have to dramatically increase the estimate for the legal costs if we're really saying we reviewed all that. $5 from Nicole says, please become an Ultimate member. We might have to. $4.99 from Richie Danger. Please accept this donation to help you pay for KJ's membership. Can't wait for your contractually obligated shout out. Yeah. In the performance of our investigation and tracking down any prior interactions between said Lori Ann YouTube account and defendant's remaining videos, I found it odd that we could not readily find any. Okay, I'm not sure why you would necessarily find that odd or not, but okay. Rather, it appeared to me that all said interactions had been scrubbed from all the visible live chats of said videos. However, on or about December the 30th, 2020, my attention was brought to a video of defendants without a crystal ball channel entitled 100K Celebration Stream. Join the conversation. Well, we just had a 20,000 celebration, so why don't you please join this conversation? Please subscribe and help us grow. If Katie, without a crystal ball, has 100,000 subscribers, I'm just saying, man, what do I got to do to get 100,000 subscribers? Without a crystal ball, it's got 100,000. Just saying. You know? Which was uploaded on channel on June the 9th of 2020. In watching said video, I personally witnessed at approximately 35 minutes therein, a person I know to be Defendant Paulson display on her video screen a message from Laura Ann's YouTube account along with a picture of a person I verified through Google's face recognition search feature to be Laura Ann Barnhart. Nice. Google's face search comes relevant for something. Dox people? Not my first choice. I then heard Defendant Paulson simultaneously say, oh, this one, Lori. Don't ever get into it with Lori. Lori remembers your names. Lori is the catalog. Lori's the catalog. Okay. Lori didn't like me at one point, and now she's my best friend. A true and correct copy of the screenshot I obtained from the video displaying Lori Ann's YouTube name and picture, which corresponds to a picture of Lori Ann's Twitter at Bloodtail. I still kind of want to know the origin of that name. Sort of, kind of. Account in declaration of Kim Fulmer and Laura Ann's Facebook account is below. And we have another picture of without a crystal ball. And Laura Ann has the little membership squiggle. I downloaded this video directly from YouTube without the live chat to Dropbox for the court's convenience. Said screenshot verifies the account had been a paid membership badge next to it. YouTube channel that pays a recurring membership fee. Yep, that's what that little squiggly would mean. Generally, the presence of the loyalty badge next to the name on the video screen means defendants have entered into a membership contract to provide Laura Ann said loyalty badge, plus other exclusive contact and services in exchange for paying defendants a recurring membership fee. As such, I have newly discovered evidence indicating defendants were receiving income pursuant to a contractual relationship they entered into with a resident of the state of Washington, and coincidentally, Defendant Paulson publicly stated was her best friend. Yeah, no, not bad. The reason this evidence was not discovered before filing the plaintiff's opposition was that I did not have any knowledge that Laura Ann existed prior to the filing of this lawsuit or a connection in Washington, and the videos that established her membership had innocuous titles unrelated to my client. Defendants have so many YouTube videos, many of which were more than an hour long. It would take an outsider like me, who is naturally unfamiliar with the contents of the videos, you and me both, brother, you and me both, years to view and catalog all of them in their entirety. The knowledge that Laura Ann is and was potentially a paying member of defendant's YouTube channel only came to my attention because defendant opened their mouth. In contravention to standard legal advice, to not open your mouth. At this point in my investigation, I was able to determine there had been a concerted effort to hide, and therefore made more difficult to find, evidence of a known connection between defendants and the person. $4.99 from David Sepulva. Lol, you got 100K. Sweet. Awesome. Thank you, man. I appreciate it. We're working on it one step at a time. I thoroughly scanned the entire live chat for the video and could not find either subject broadcasted Laura Ann's comment nor any other comment anywhere in the live chat. However, I did find indications that multiple comments from Laura Ann's account did exist previously in the live chat. So multiple comments did exist, although I couldn't find out what they were, presumably because they were deleted. By way of example, not limitation, I personally observed that other participants of said live chat during the June 9th, 2020 live stream were directly conversing with a person using Laura Ann's YouTube account in said live chat, but all statements and responses from the side of Laura Ann's YouTube in the chat were deleted and now missing. Suggesting spoliation. Spoliation by who, though? It would only be spoliation, strictly speaking, if it was Katie who was doing it. And I think the person themselves can delete their comments, so it's not necessarily spoliation. But it's not there. Below are true and correct copies. A screenshot obtained from a current replay of the chat demonstrating this irregularity, in which I've highlighted screenshots to draw the court's attention. So we got some tattoo guy who's got some muscles, hey, and we got Katie here in a Joyfully shirt. So, hey, first of all, this guy on Katie's right is pretty buff. So, just saying. You're looking good, dude. How about that? You're looking good. You got a very sort of bro bear thing going on for you, but it looks good for you. And Katie, she's got the Joyfully thing, which is plus. And then we got some people saying, don't forget Tina at Lorianne. So people are talking to Lorianne. That's plus. That's her husband? Okay. Well, and so much as a straight guy can say another guy is rocking, hey, Katie, you're doing well for yourself. Way to go. Thereafter, I discovered all the previously identified Lorianne live chat comments from defendants' affirmation live videos were also deleted. I wonder if, with a physique like that, I can't help wondering if Toad over here, and, no disrespect, because, a person who takes good care of their body probably does use supplements of some kind. Creatine, for example, would be a classic choice. Creatine monohydrate, classic choice to help build muscles and help get an extra couple reps out. Maybe some protein, classic for someone lifting weights. And a lot of people who lift weights, really like to have some extra vitamin supplements to really help their channel grow. And if you're looking for vitamins for your weightlifting needs, might I suggest the quality vitamins of Halo Beauty products. Halo Beauty products, here to help weightlifters everywhere. In addition to the deletion of all said Lorianne's comments as stated above, I discovered the aforementioned Lorianne YouTube account had been permanently deleted sometime after defense broadcast of the December 29th live stream. Furthermore, I also discovered that said Lorianne's Facebook account and said Lorianne's Twitter account were also deleted within close proximity of the time that Lorianne's YouTube account was deleted. The deletion of social media accounts, I noted. Oh, man, I have way too much fun with this. The defendant, the deletion of social media accounts I know to belong to Lorianne's occurred after connection to defendants was disclosed in plaintiff's opposition, including, but not limited to, the existence of direct messages between Lorianne and defendants. It is my belief that deletion of Lorianne's social media accounts was in response to the presentation of evidence of a close relationship between defendants and Lorianne Barnhart. Further, on January the 2nd of 2021, so this would be like 3 days ago. Yeah, the gods of speculation didn't expect this when Nate suggested this document. I did not suggest that, no. Yeah. Who needs sleep when you have Halo vitamins? That's right. Further, on January 2nd, 2021, I observed yet another live stream on defendants Katie Joy's LiveTube channel, which additional relevant information regarding even more known paid watching members was disclosed. I downloaded from YouTube a true and correct copy of said video without the live chat, which I put in the Dropbox. At around 35 minutes into said January the 20th, 2021 live stream, a person using the name Adi, taking trials and stuff, which is a YouTube handle of a paid member as identified as having contract with defendants to receive exclusive content and services from defendants, states in member-only chat that she lives in Washington State. Dun, dun, dun. And then later apologized for mentioning her state. Yeah. A true and correct copy of the screenshots I obtained, which also displays the loyalty badge. I seriously have to wonder. I don't know. I don't know if one way or another, because there's no particular reason that KJ or his lawyer or her lawyer or Toddy or her lawyer would be watching my videos. They might, but there's no particular reason for them to. They might be interested just to see what the coverage is or not, or they might not because we're not a party. So I wonder what the probability, because it's not 0, but it's not 100%. I want the probability that either Toddy or her lawyer or KJ or her lawyer are watching this video right now, perhaps taking screenshots of this video. If I get mentioned in a future legal document, I only request that you try to get a good screenshot still, make me look good. Hopefully that will help you with your screenshotting needs. A true and correct copy of the screenshots I obtained from this live stream of Adi's statements, which also displays Adi's paid loyalty membership badge, are below. We live on the side of a hill of Washington State. We learned how to deal with yellow pollen over everything from there. Sorry, my fault. I mentioned my states. Yeah, just randomly stop every few minutes and pose. I like it. You know, we could do the bad boy. We could do the Texan. We could do the hat. At around 38 minutes into said January the 2nd, 2021 live stream, Defendant Paulson tells her members not to share where they live. Defendant Paulson says, please don't ask people where they live. Don't talk about where you live in general. If you live somewhere, that's fine. Well, everyone lives somewhere, I suppose. Then around 40 minutes into the live stream, Defendant Paulson stated that the live chat was being monitored. It appears that maybe the only way for me to get Toddy's lawyer's attention is to comment in a KJ live stream. And that'd be good, just to get their attention. Be like, hi, I'm Uncivil Law. I'm from Washington State. Not really, but now that I have your attention, Toddy's lawyer, I'd love to talk to you. Please contact me on Twitter. Oh, man. It's apparent this statement from Defendant Paulson was a response to Adi, who has since apologized in the live chat for sharing that she was from Washington, and thus providing further evidence of the fact that defendants not only have actual knowledge they have contractual relationship with another resident of Washington, but also defendants have actual knowledge they continue to derive additional income from the state of Washington through recurring membership fees. Thank you, Sea Sloth, and thank you, Hot Bindi, for becoming supporters. I appreciate it. The newly discovered evidence identified herein is additional evidence that defendants have not been forthright in their motion to dismiss with regard to their contacts and additional income derived from Washington. Not only should defendants have known at the time Defendant Paulson signed his declaration they had a contractual relationship with Washington residents from which they derived an income, but also defendants most certainly know now they have a contractual relationship from which they divide an income. Yeah, that motion to dismiss for lack of personal jurisdiction is looking weaker and weaker with every passing moment. All the evidence set forth above conflicts with the statements in our declaration. To my knowledge, neither I nor Without a Crystal Ball has any sponsors or subscribers. To my knowledge, neither I nor Without a Crystal Ball derives any income from Washington. That would contradict it. So yeah, that motion to dismiss for lack of personal jurisdiction is looking weaker and weaker with every passing moment. $4.99 from Boobs is silly. Maybe you'll be mentioned for your sharded pearls of wisdom. Here's $4.99 tip to start a new hobby. Okay. Excellent. Thank you. I appreciate it. Answer your Discord. First of all, that's a little bit demanding when I'm doing a live stream, but I will check my Discord real fast because why not? Someone who said that they're a broke mother. No one has to be a member. And if you're broke, I totally understand. It'll be your first account when I hit it big. I'm sad I broke. Can't give a shout out. That's fine. I appreciate your watching. You know, you should only give if you can. I mean, you know, if you don't have money, don't give money. You know, I totally understand. I made the membership fee 99 cents, which is as low as I can make it, you know, because I realize not everyone has $4.99 to shell out to everybody. But, you know, not everyone has 99 cents either. So if you don't have 99 cents, I'm very happy that you're just here. And no disrespect. I understand some people really live on very tight budgets. I totally get it. So I just appreciate, I'm happy you're here. So thank you for your comment. That was very nice of you. So let us read the last document, which is a joint status report and discovery plan. It's a little early for this, in my opinion. So, it's a little early with motions to dismiss outstanding, which suggests that Katie's lawyer is not particularly convinced the motion to dismiss is going to be granted. It's a little bit early for this. Is there a link for membership? There's not a link for membership. If you're on an iOS device, I don't think you can subscribe on iOS because iOS takes a cut of everything. So you have to do it from a computer and an Android device. But if you're on one of those devices, it should be on the screen somewhere where the subscribe button was. You might have to close the chat on some devices. All right, so we have 6 pages of a joint status report and discovery plan. The parties, where are we, and what is our plan for discovery? Okay, great. Parties conducted a conference on December the 18th. Pursuant to the federal rules of civil procedure and local rule, the parties submit this joint report and discovery plan. Initial disclosures. The parties are filing a stipulation and proposed order to stay discovery, including the requirement for exchange of initial disclosures pending the court's decision on the defense motion to dismiss. Fair enough. There's no reason to have discovery before the motion to dismiss is granted. The stipulation and proposed order will include an exception that will permit plaintiffs to issue subpoenas for Laura Ann Barnhart's social media and internet content, as well as her communications with defendant, that they believe may have been lost in the absence of such subpoena. Laura Ann Barnhart, you get a subpoena. Congratulations. A defense motion to submit on lack of personal jurisdiction is denied. Parties agree to initial disclosures within 14 days of denial, which is a little aggressive, but if that's what they agree to, that's what they agree to. Subject timing and phasing of discovery. The parties do not seek to conduct discovery in phases. The parties anticipate discovery on subjects related to the claims asserted by plaintiffs in the complaint, as well as discovery related to raised. The parties proposed discovery will be completed 60 days before the trial date. Okay. Electronically stored information. The parties have agreed to use the model protocol for discovery of electronic secured information. The court has also signed a stipulated order regarding the preservation of electronically stored information. Fine. The parties agree, pursuant to the federal rules of civil procedure, any claims of applicable privilege or protection will be made at the time of production and accompanied by a privilege log that includes the privilege asserted, the date and description of the document, and the name and title of the author and recipient. That's very fair. So we have to produce documents, but anything privileged can be marked as privilege, and you do this in a privilege log. That's the way you typically do this. The parties also agree, pursuant to the federal rules of civil procedure, if information produced in discovery is subject to a claim of privilege or protection as trial preparation material, the party making the claim may notify any party that received the information of the claim and the basis for it. Okay. After being notified, a party must properly return, sequester, or destroy the specified information, any copies it has. Otherwise, it must not use or disclose the information until a claim is resolved, must take reasonable steps to retrieve the information as the party is disclosed before being notified, and may make promptly request to present the information to seal for determination. The producing party must preserve the information until the claim is resolved. So this is just how to deal with privileged information that's accidentally disclosed or otherwise. Fine. The parties agree that federal rules of civil procedure and local rules provide sufficient limitations on discovery, and no additional limitations are needed or requested. Interesting. I would think that Toddy's side might want additional things. I mean, there's stuff in the rules dealing with trade secrets anyway, but I think you'd want something on top of that. So it's a little bit interesting that they didn't insist on something on top of that. It's not necessary, but it's just a little weird. In addition, parties contemplate significant additional time than permitted by the federal rules of civil procedure and local rules will be necessary to depose. Yeah, no joke. Due to the quality and length of videos and other content, they're relevant in the claim of the defense. Yeah, I would imagine that depositions are going to go on for a while. The parties anticipate the need for discovery order, expanding the time allowed for the depositions. Yeah. As stated above, they filed a stipulation of proposed order for stay, pending the motion dismissed. The parties do not anticipate the need for additional orders at this time. Yeah, we're going to definitely need the court's permission to extend the depositions, I would think. The parties may file dispositive motions to eliminate or narrow the issues for trial, such as the motion to dismiss. Alternative dispute resolutions. The party agree that mediation is an appropriate alternative dispute resolution. The parties have further agreed to use best efforts to attempt alternative dispute resolution 60 days before trial. So they're agreeing to try mediation. It's a little bit interesting. It's a little bit interesting that they're planning mediation that late, because 60 days before trial is also the time that discovery is finished. So, it's just interesting on the timing. There are no related cases. They're agreeing that there's no related cases. So they're agreeing. This is an interesting concession from Katie's side. They're agreeing that the dispute between Toddy and the business partner is not a related case, which, it's not related. But the fact that they're stipulating to that is a little bit interesting, because it takes away a potential avenue from Katie's side. I mean, it's a pretty good argument in any case, but they're taking away an argument that the partner lawsuit is related. Now, strictly speaking, it's not related. Well, that's actually helpful to Katie's lawyer too. It's a strange stipulation from both sides. It's a bit strange from Katie's side, because Katie is saying the business dispute has nothing to do with their dispute, and that information might be helpful to Katie. It's also a strange stipulation from Toddy's side, because to the extent, if any, that her business partner is feeding information to Katie or the lawyer, they're agreeing that the cases are unrelated as a matter of stipulated fact. So that takes away arguments from both sides. Strikes me as a strange stipulation. Okay. Discovery management. The parties have agreed to work cooperatively in discovery to minimize discovery-related expenses. They issue a standing order setting forth the process for managing discovery disputes. The parties have no other proposals for discovery management at this time. Fair enough. The parties anticipate discovery-related claims in the complaints. The parties do not include any phasing of anticipated motions at this time, so they don't plan things to be phased in or phased out or go into effect at different times. The parties have agreed to take reasonable and proportional steps to preserve potentially relevant information. The court has signed a stipulated order to that fact. Given the nature of the dispute, privilege issues may arise regarding whether attorney-client and/or work product privileges apply to otherwise discoverable documents. See paragraph 1D for the procedures for handling that, which is an exchange of a discovery log, which is very typical. The parties do not propose any modification to the model rules for electronic stored information. The parties have agreed to model protocol and do not propose any alternatives. Signed them. Okay. So that brings us to the end of these three documents and the end of T hour. I know you're sad, but we have reached the end of the documents. There is no more tea. I know. It's sad, but it's true. We've read all the documents and there just is no more tea at this time. $4.99 from No Names, Just Opinions. Say you love me. I love you and everyone else. Everyone gets a piece of Uncivil Law's love. So that's the end of that tea. It's not even my birthday, but he wanna lick that icing off. I know you want it in the worst way. Can't wait to blow my candles out. He want that T. But alas, we have reached the end of the tea. There is no more tea. It is over. So what did we learn? Well, I think we learned that the probabilities continue to grow that this motion will not be dismissed for want of personal jurisdiction. As we've done more research on this and we've become more informed, the standards in the Ninth Circuit seem particularly loose compared to other circuits, and it seems like they don't require particularly much. And it appears to be true that she did have income and membership that was derived from Washington. And between that and the other things she did in Washington State specifically, in terms of seeking documents and other things, it appears that there may be enough after all. So, yeah, I think we would expect and anticipate at this point the motion will not be granted for dismissal of the personal jurisdiction. And we are still waiting for a response to the response from Katie's lawyer and see if they come up with anything in terms of this. I mean, presumably they're going to have to respond to this, at least in part. And if I were Katie's lawyer, basically I'd be trying to argue that there's nothing particularly special about the Washington members. That'd be what I'd be trying to argue. There's nothing particularly special about I know it's not going to work, but this would be what I'd try. If I'm Katie's lawyer at this point, I'd be like, yeah, there's nothing particularly special about the Washington members. She's a channel that has 150,000 subscribers. We can reasonably assume that she has people. I mean, at this point, you might as well steer into this good. You can reasonably assume that she has people watching her from every single state. You can reasonably assume, given the size of her channel, that she has at least one member from every state. So, if you accept Toddy's theory of jurisdiction as true, it would imply, using her own legal theories, that there's personal jurisdiction everywhere because there's nothing particularly differentiated about Washington. Now, that's not going to fly. By the way, that's not going to fly because the business is based, the biggest liability on the counter for that from Toddy's side is not Toddy and not James, but Halo. Because it seems like Without a Crystal Ball was well aware that Halo was based in Washington. So whatever she did or did not think about where Toddy and James were, because there was some conflicting information. There was some information they had a home in Los Angeles, which one could assume they lived in. And even if she said that at one point she lived in Washington, she might have thought they also lived in Los Angeles. So there's a little bit more argumentation when it comes to the Toddy or James residency. What's less ambiguous, however, is the residency of Halo. It seems like Halo is and always has been based in Washington, as best as I can tell. And it doesn't seem like Katie had any information to the contrary to that at any point. And they did, the business did bring a complaint in their own name, and there is elements of defamation against the business as such. And if you have personal jurisdiction for one reason, you have jurisdiction for all reasons. So Katie's biggest point of liability is not to Toddy and not to James, in my opinion. It's actually to the business for the personal jurisdiction issue. Personal jurisdiction issue. Now, when it comes to other issues, her liability for damages and stuff is going to be greater elsewhere. But for the personal liability issue, I think that Halo is the biggest liability. And there doesn't seem to be anything that would ameliorate that liability as best as I can tell. So if Halo has personal jurisdiction over Katie, then so does Toddy and James. So therefore, they all do. And if they have it for one reason, they have it for all reasons. So I think the probability of this getting dismissed on a motion to dismiss is looking very, very thin indeed. Now, excuse me one second. That being said, however, my best research on this indicates the Ninth Circuit is particularly loose on this, but I think that this could come down to the eccentricities of the particular judge. So although I'd say, I don't know there's a particularly good way for me to phrase this. Like, I'd say it's 90% plus, but in some ways I don't feel confident about that. Like, my error bars are really wide because I think that there's a lot up to the personal jurisdiction or the personal taste of the judge. So, like, I think Toddy has a 90% chance of winning, but like the error bars are really wide. So I'm less confident about that than 90% would suggest. So maybe 90% is the wrong number. Maybe I should be putting it down to represent more uncertainty. But in any case, yeah, I think this could come down to the eccentricities of the particular judge. And then you would assume, all else being equal, that the judge would be unlikely to dismiss for personal jurisdiction because most judges like jurisdiction. They like to have it. So they don't want to give it up if they don't have to. So Halo's based in Nevada? Are they? But they're run from Washington. Their principal place of business is Washington. So that means they're domiciled in Washington. So Nevada and Washington. Yeah. Okay. So that will do. Yeah. So when you're thinking about where a business is resident, a business has two residences, where they're incorporated and where their principal place of business is. So a business has two places of legal residence. And yeah, so I think there's enough there. Mediation would suggest talks of a settlement. Yeah. And it's interesting that it's that scheduled that late. But yeah, that's what's going on. So that's what's going on. I have 905 viewers right now. That's a lot of viewers. I feel honored. Thank you, 905 viewers. That might be a record for a personal stream, for a stream not with a guest. I think I've done better than that with a stream with a guest, but I don't think I've ever done that well on a stream by myself. So I think 905 might be a record for a stream by myself. So thank you very, very much to all of you who are watching from presumably all over the United States, including Washington, one would presume, just by sheer numbers, you know? So thank you very much to all you who are watching. Might I be so humble as to please suggest, if you haven't done so already, please subscribe to my channel. I'd really like it. And, you know, the more subscribers I have, the more it will show up in people's feeds, the more it will feed the algorithm. Please like it. Please subscribe. Please comment. Please all those things. Because, hey, we hit 20. First of all, we grew quite a lot recently because we were at 19,000. Well, we were at 18,500 about, I don't know, a month ago or something. And then we hit 19,000 like 4 days before the new year. And we tried to hit a stretch goal of 20,000. And we hit 20,000 for the new year. That was really, really cool. And now we're up to like 20,600. And that's really cool. And also, for those of you who have been watching and, you know, have been seeing new content, I've been experimenting with new short content as well to do more political stuff as well, because this is something I've talked about on my channel quite a lot, and I'll talk about it here. And I'll also talk about it more tomorrow. So we're going to have a stream tomorrow at 7 o'clock Central, where we'll do questions, answers. We'll talk about anything you want, you know, within reason, obviously. We'll do State of the Channel. We'll do channel updates. We'll take questions. We'll take questions from the audience and talk about anything you want. We can talk about more about this lawsuit. We can talk more about personal jurisdiction stuff. We can answer and clarify questions. We can talk about more politics. We can talk about anything you want. It'll be pretty open. So that'll be tomorrow at 7. It'll be the first of a new series of weekly. So we're going to try Tuesday at 7 and see if that time works for people. And if it works well, then we'll do Tuesday at 7 for the weeks that follow. That's the working plan. So that's something new that we're trying on the channel. We've done impromptu membership streams before, impromptu Q&A streams before. So this is not new in that sense, but it's new in that we're going to try to have a scheduled regular time for it and try to do it on a regular basis instead of it being impromptu. So that's new. Another new thing that we're doing is we're doing these short political views. Now, I've always on my channel made a point many, many times of saying how I split political from legal. And legal is not the same as political, and political is not the same thing as legal. I make a point on my channel, I've said it many times for anyone who's been here for any length of time, that I think the legal is very different from political and vice versa. So in my legal commentary, I try to provide a very sort of neutral legal position. Now, my position is conservative, but not necessarily Republican, or more, to put it more properly, it'd be originalist textualist, which is considered to be a conservative viewpoint. But it's not really Republican. It's not partisan as such, because it's not really about the Republican Party. It's about originalism and textualism, which is associated, but these are nuances that matter, at least to me, right? It's not about party loyalty. It's about actual ideological and interpretive doctrines, and I try to apply that in a very consistent and neutral way in my legal commentary. What we started trying to do is try to do these political shorts. So we're trying to do under 5 minutes, and we're just trying to do little political shorts. And these are going to be very right-leaning. They're just going to be very right-leaning, very Republican, big R Republican, conservative political. And I don't consider that, you know, problematic in any way. We'll still do the regular legal content that you guys know and love. That's not going anywhere. So the legal content will still be the same legal content you've always seen, with the same neutral interpretation as you've always known and loved, you know, because I split the legal and political, as I've said many times on this channel. So I'll continue doing the legal commentary the same as you know, and we've also tried to do these political hits or these political stories in an attempt to like try something different and see if it works and see if it helps grows the audience and see if people like it. And God knows there's enough to cover, you know, in politics right now. The Georgia Senate race is tomorrow. So 2 members of the Senate are being decided tomorrow in Georgia. So guess what we're talking about tomorrow? The day after that, what are we talking about? Oh, I don't know. The counting of the Electoral College votes, maybe? That would be what we're talking about in 2 days. So we're talking about that. So we're trying some new things on political outreach to do more political theme stories. So we'll see if it works. We'll see how it does for the audience, see if people like it. But we're giving that a shot, and, you know, I'll be happy to talk more about the rationales behind that tomorrow. So if you have questions or whatever, but we're still going to have, you know, so we'll do these short little segments, 3 minutes, 5 minutes, maybe 8 minutes short, and then we'll have the regular legal content 20 minutes, 30 minutes, or whatever long it takes to actually do deep dive legal analysis. So, all that good stuff. So, yeah. 989 from Classy Mom. Constitutional issues. Really want some commentary on New York's SB 418 as constitutional to stick and set precedents. Well, let's see what New York SB 418 is, because I don't know every bill proposed by the numbers. This establishes a felony for assault of a school employee. I mean, I don't have any particular position on that. I mean, you want to make, is it constitutional to create a new thing for assault? I mean, almost certainly. Establish assault on an employee acting in a place a person knows is on a school ground with intent is a C felony. Okay. I mean, I can't see any problems with that for Senate Bill S14 off the top of my head. So, yeah, so I don't see any problems there. Boxers or briefs? Boxer briefs, man. It's the only way to fly. Boxer briefs. If the Georgia senators are contested, who is seated for Georgia on the 6th? Possibly no one. I don't know exactly what the certification process is in Georgia in terms of the time or something, but I don't know exactly what the issues is. But I mean, if it's really, really clearly a blowout on the 5th, such that they can term on the 6th, then maybe. But it might be nobody seated on the 6th. It might be too early. It depends how long it takes to, because the vote has to be officially counted. It's officially certified. So maybe nobody, unless it's a really, really clear blowout. I've tried not to overburn yourself. That's fine. Yeah, we're doing fine. A good video about why the Electoral College is a thing would be great to dispel the notions only based on slavery. Yeah, I mean, it's based basically on federalism is the short answer. We're a federalized republic, and, voting by states is a way to reflect the sovereignty of the individual states. This is also incidentally why senators were individually appointed by states rather than being elected. Was also in part of the federalism, because you had the House of Representatives that spoke for the people, which is good. The people have a voice, and the people's house is the House, and then the Senate was the states themselves appointed senators before the 17th Amendment, and so the Senate spoke for the states as such, the institutions of the states. And then, of course, you changed that through the 17th Amendment, but that's also part of the federalism balance, was because, it's essentially like countries within countries, kind of, sort of. So it's kind of like the European Union, except tighter than the European Union. So every country/state gets representation in the centralized government, and you go from there. But that's what's really going on. Does Trump still have sovereign immunity for the bullshit he pulled on the phone with Georgia's Secretary of State? For the moment, he does. But he's going to lose that sovereign immunity real fast come January 20th. And I think that's outside of his scope of his office, so I think his absolute immunity is also running pretty thin. I think YouTube likes 8-minute videos. Can't you add mid-rolls at 8 minutes now? Something like that, and you can get advertising on 8 minutes, but we're trying to make them shorter than that. We're not monetizing them. Senate Bill 416. In New York, let's see. Enacts into law major components of legislation necessary to implement the state education, labor, housing, and family assistance budget. Residency requirements for qualifying for scholarships for higher education. Repeals some part of the education law. Some sort of state dream match relates to capital arts grants. This is state spending power related to education. This is a big bill. So you're going to have to be a lot more specific than that. Wait, is that the right bill? No, hold on. That's the wrong bill. Oh, this is the public health law? Yeah, dealing with the mandatory quarantining of something. Yeah, we're definitely going to have to get into that at some point. We definitely have to get into that at some point. Why do people always think it's just because someone supports KJ, it is KJ? I mean, yeah, she does have fans. I mean, it's a very fair point. Yeah. Is it not legal to defame people? You don't have freedom to do so. That's true. Yeah, you can't defame people. The phone call was part of litigation. Questionable. Questionable. Am I familiar with Thomas Jefferson throwing out Georgia's electoral certification? Sure. Yeah. Yeah, throwing out stuff has been before. It's been happened before. I feel like the court of opinion decides she already defamed Toddy. I'm not convinced. Yeah, I think the defamation claim, as I said before, and I'll say it again. I think the defamation claim for Katie, it looks pretty good. She has obvious public figure status issues, and she has obvious public figure defenses. She has obvious opinion defenses, and to the extent that she is expressing factual statements, she has obvious underlying truth statements, opinions. So I think in terms of defamation, I think she has. I think in a perfectly argued case, I think I'd rather have Katie's side of the argument than Toddy's. I think Katie has the better end of the perfectly argued case. Now, that's just a personal opinion. But yeah, I think in the defamation side, I think if Katie pulls it together, she could really get somewhere. Now, I think one of the problems she ran into in the way she dealt with the motion to dismiss was she opened herself up to more liability than I think she would have if she had moved to dismiss the defamation as part of, because it made the other arguments look stronger because they didn't have the contrast. So you could have the exact same argument for the negligent infliction of emotional distress, but it looks stronger in contrast. It'd be like, I don't know what the equivalent would be. It'd be like having two items on a menu. One that's $500 and one that's $50. So if you have two items on a menu, one that's $500 and one that's $50. So if you have three items on a menu, one that's $500, one that's $50, and one that's $10, right? So if you have three items on the menu, one that's $500, one that's $50, one that's $10, the $50 item looks comparatively inexpensive because it's framed in the context of a $500 item, right? $50 is $50 in the abstract. So in the abstract, it's a $50 item. But like anyone who knows anything about marketing at all, or like anyone who uses their imagination, right? If you have two items, one that's $500, one that's $50, one that's $10, right? The $500 item comparatively makes everything look cheaper, even though it's not cheaper. It's exactly the same price it would have been anyway, but it looks cheaper by the comparison, right? So because you have the $500 item, it makes the $50 item look cheaper. Whereas if you get rid of the $500 item, so now all you have is the $50 item and the $10 item, the $50 item suddenly looks more expensive. So in a menu with only the $50 item and the $10 item, the $50 item looks more expensive because it's now the most expensive item on the menu. It's no more expensive than it was before. It's the same exact price it was before. But it looks more expensive because you don't have the anchor comparison, right? The $500 provides an anchor point of comparison. This is basic psychology, basic marketing. So anyone who knows anything about marketing, this is not like a revelation, It's like, yeah, if you have a $500 item and a $50 item, the $50 item looks cheaper in the framing of the $500 item. Without the $500 item, the $50 item looks more expensive because it's the most expensive thing, right? So, yeah. So the negligent influence. So in this metaphor, the reason I'm bringing all this up, in this metaphor, the intentional infliction of emotional distress, the negligent infliction of the emotional distress, the civil harassment claims are the equivalent of the $50 item in this metaphor, right? The defamation was the $500 item. So the $500 item, the defamation, made the $50 item look pitiful. Made it look meaningless. Who cares about $50? It's $50. Who the fuck cares? It's $50, right? So the $500 item, the defamation, made the $50 item, the negligent infliction, the intentional infliction, the civil harassment, look more inexpensive by comparison. But because Katie never moved to dismiss the $500 item, all that's left is the $50 item. So it looks more expensive. It looks more than it was before by simple psychology, because there's nothing to anchor it against. It's now the most expensive item on the menu. So if Katie had moved to dismiss, even if she lost, which I think she had a pretty good chance of winning personally, although Emily disagrees with me. She thinks the odds are less good than I do, but that's a split of opinion that two lawyers can have. I think the odds are better. But if she had done it, even if she lost, she would have necessarily made the other items look pitiful and meaningless, right? Because the defamation was the meat of the case. Who cares about this $50 item and this 10 item bullshit? Who cares about the $50 and $10 bullshit when we're talking about $500 items? Who cares? Doesn't matter, right? But because there wasn't that anchor, because she never raised the move to dismiss the $500 item, you know, the response was, well, look at this $50 item, and it looks really expensive because there's nothing to drag down its perceived value. So I don't know if any of that made any sense, but that's why her failure to move to dismiss the defamation drove me so crazy, because it was the heart of her case. Like, who cares about this $50 bullshit? Who cares about this $10 bullshit in the light of this $500 bullshit, right? That's what's going to kill you, is the $500 bullshit. Who cares about and these are not real dollar amounts, you understand, right? I'm not saying it's a $500 cause of action. These are just completely arbitrary numbers for the purpose of illustration. I could have said $10 and $5. I could have said $10 million and $5 million or something. These are just completely arbitrary numbers for the purposes of example. I'm not saying the defamation is a $500 cause of action. You guys are following that far along, right? You understand that, right? I was just using completely arbitrary numbers for the purposes of illustration. Figure I should make that clear. I wasn't trying to say the defamation was only worth $500. That wasn't my point. I was trying to say it is like a $500 item and a $50 item in a comparative world. That was what I was trying to say. So the failure to move the defamation made the other cause of actions look more real than they would have otherwise. And so, yeah. So that's what drove me crazy. So, yeah. So so even in chat when I was doing the stream, and people were saying, well, because Katie allegedly said something about James pulling the plug on their mother for the purposes of inheritance. And someone said, well, isn't that really awful? And I'm like, yeah, it's really awful, but, you know, the defamation. But it's the most awful thing I've heard. Yeah, but I'm like, the defamation, though. The defamation is I mean, it's bad, but it's only $50 bad. It's bad. It's $50 bad, but it's only $50 bad. I mean, defamation, though. The defamation. And they never moved to do the defamation. And it's like, this statement's really horrible. I'm like, yeah, but it just wouldn't matter in comparison because the defamation's everything. What do you mean it wouldn't matter, Kurt? This is what I'm talking about. You know, it drives me crazy sometimes. Yeah, so they're in a weaker position than they would have been otherwise. You know, that's yeah. Yeah. And this is market perception thing. This market perception thing is also a very good way of just viewing appellate arguments in general, or arguments to the jury in general. Although I think of it more in appellate arguments. Because I'm more of an appellate guy rather than a trial guy. Emily and I had that discussion too. She likes the trial because she likes the tea. I don't really do tea. I do law. It's like someone else can deal with the tea. Now I'm doing more tea than I ever wanted to, but that's fine. But this is the same problem you have in appellate law. right? I mean, fundamentally, it's the same problem. It's like suppose you're a trial attorney and your client has lost, and you think you as the trial attorney think that there are 10 errors, 10 legal errors the trial court committed, right? So you think the trial court committed 10 legal errors. All right. So you're the appellate lawyer. Here's the question. How many errors do you raise to the Court of Appeals? Right? You think the trial court committed 10 errors. You want to appeal to the appellate court. How many of them do you raise to the appellate court? How many of the 10? And the unsophisticated answer to this question is 10. That's the unsophisticated answer to the question. They made 10 mistakes, raise all 10. That's the very unsophisticated answer to the question. It's an unsophisticated answer to the question because what I didn't tell you is how strong they are, or how important they are, or how meaningful they are, or how good my arguments are. I didn't tell you anything about the comparative strength of them, right? And you have to worry about these problems when you're raising issues for exactly the same reason. Because, it's kind of those things that the least thing tends to hurt you, right? The thing that hurts you the most, it's the weakest link in the chain, kind of. The weakest link in the chain is the thing that tends to kill you. So if you have 9 really good arguments and 1 shit argument, if you have 9 good arguments and 1 shit argument, odds are decent. The 1 shit argument is going to make the other 9 look weaker in comparison. Because, this 1 argument is shit, so surely the other 9 must also be shit. Right? This is just normal things that people do in their own psychology, right? I'm not telling you anything that you don't do in your own normal life, right? Someone tells you 10 things. A person tells you 10 things. One of the things you discover to be lies. What do you assume about the other 9? Right? Or a person tells you 10 things. One of them turns out to be particularly reliable and particularly trustworthy. What do you conclude about the other 9? Right? So this is just natural psychology. It's just stuff everyone does as sort of stuff too. So this is stuff you have to worry about too on appellate law. It's like you don't necessarily want to bring all 10. Maybe you want to bring 5. Maybe you want to bring 3. Maybe you want to bring 1. Or maybe you want to bring all 10. But these are some of the things you have to calculate about. And it's the same sort of things that can go wrong here. It's like not every argument's the strongest. Not every argument is equally good. And you left the weakest argument on the table. It made everything. And because you left the weakest argument on the table completely unanswered, made everything else look stronger. And now you're in a much weaker position than you had to be because you've crippled yourself when you didn't have to, because you had really good ways of attacking this $500 argument. And you could have said, I can reduce $450 of value. Right? You say it's a $500 argument. Here's a whole bunch of arguments I have. I can take $450 of value off of it. And then the court says, well, this was a $500 item. You've taken $450 off of it. So you know what the hell? Let's just round it all to 0. Let's just round it all to 0 and let's all go home. And that's, courts look for easy roads too. So, if you get 90% of the way there, the court might just say, oh, fuck it. Let's all go home. That's a thing that can happen. It's a thing that can happen in appellate law too, right? It's for the same reasons. It's like you can work the other way around too. It's like, you got 95% of the way there. That's close enough. Let's just round up. Things like that can happen. So you don't want to lend those opportunities. You don't want to lend to those possibilities. And it's like, who cares about this nickel and dime shit? We've gotten rid of the big item, So, yeah. That's kind of what's going through my head. And where I think Katie's lawyer put themselves in a much weaker position than they had to. Now, the personal jurisdiction argument, I didn't know at first. I looked into it. The personal jurisdiction argument is separate from substantive, right? The personal jurisdiction argument is in a different world, somewhat at least. So I didn't know initially, and I thought, okay, the personal jurisdiction argument, I don't know. It's different than the substantive argument. Now, I'm reasonably convinced the personal jurisdiction argument is not going to work for Katie. I think that Toddy can get personal jurisdiction. I think this lawsuit will stand. I'm not super confident about it because I think some of it's up to the individual judge a little bit, but, I'm confident-ish that this is going to survive and this lawsuit's going to go forward. Definitely more confident than when I did like 3 hours of legal research in preparation for my talk with Emily about it, where I did some deep dive legal research, actually look into it. So, I'm reasonably confident that this is going to stand. And now on the substantive argument, the big substantive monster is the defamation. And it's like, what are you going to do now? I mean, the answer to that question is you're going to try to attack it in the answer. I mean, that's the next thing that's going to come substantively, presumably, after we dick around on the motion to dismiss crap for a while. So we're going to, we have some responses, and presumably the next thing that's going to happen, eventually at some point the court's going to make their motion to dismiss judgment, which will probably be denied. And then presumably the next thing that's going to happen is what's called the answer. And at that point, Katie presumably is going to attack the defamation cause of action in her answer. And I guess we'll see how brilliant that is. We can only hope. And if she has any counterclaims to bring, which I don't know exactly what that would be, presumably maybe a reverse defamation lawsuit. She wants to bring her own lawsuit. She could file that at that point. But like, she's in a weaker position than she had to be. It was a completely unforced error, in my view. So, that's kind of where we are. So, we will see. But I'm going to go to bed. I have to get ripped like Toad. Toad is the new inspiration for my weightlifting journey. Because Toad knows where it's at. I wonder if Toad has a personal fitness channel or something that I could subscribe to. Because apparently he knows about the personal fitness. So, Toad is a inspiration to us all on this New Year's as we try to better ourselves and reach our journeys, as I look into the abyss of my 40th birthday, which is coming up next week. Very sad. If you have not done so already, please, if you'd hit the subscribe button, I would appreciate it. If you have not done also already, please like the stream. Please hit the subscribe button. I don't care if you're from Washington State. I don't care if you're Toddy's lawyer. Hello, Toddy's lawyer. I don't care if you're KJ's lawyer. Hello, KJ's lawyer. I don't care if you're KJ. Hello, KJ. Katie, I hope it works out for you. I hope your lawyer has a strategy that I'm just not seeing, and the grand plot will be revealed, and I'll have to do a big mea culpa about how I didn't see the brilliance. That'd be good. So hope all that works out. I'm going to sign off for now. Until later, my friends. Cheers and goodbye.